to introduce David Mears, who's a partner at Russell Cooks, who's going to talk about, well, a number of things: risk and mitigation, termination, dispute resolution,
data protection,
and data protection.
Yeah.
Great.
Thank you very much. Morning, everybody. As with James, I'll have to take questions as we go, as long as they don't take up too much time, because we are time limited, obviously. And I'll try and keep pretty much the time on each of the three slots I'm covering in the next 40 or 50 minutes or so. So I'm going to be talking about mostly about things which are within the ISPA. So that's the sort of context of what I'm talking about. The first session is quite broad, risk and mitigation, but it's quite broad and it does overlap to an extent with what James was saying. There are some references in there to the ISPA itself, as there will be in the following two sections. Can you all hear me okay? Because I'm sort of vaguely near the microphone. Good. Okay. Okay, but James touched on this a little bit. The legal structure of the organisation, very important to know what sort of organisation you're in and what the consequences might be of the structure that you have. Very much not appropriate to use what we call an unincorporated structure. The most common ones are a trust or an unincorporated association, but equally a sole trader, very unlikely that anybody would have one of those, or a partnership, pretty unlikely. They're also unincorporated legal forms. And the reason there is all about risk of personal liability. There is no limited liability structure, no sort of risk wrapper, if you like, around your organisation if you're unincorporated. So all the contracts and all the relationships that you have as an unincorporated association or a trust with the outside world, you may well have contracts that name, say, your ABC charity. Your contracts say that it's with ABC charity. If you're unincorporated, the reality is that's a contract between the outside world and the trustees personally. It doesn't matter that they're not named on the contract, they are effectively legally liable under that contract. So there are significant and risks you shouldn't take of entering into this sort of highly specified contract through an unincorporated organisation. Of course, on the other side, there are benefits of using a limited liability structure. And I've mentioned a few here. The CIC, some of you may know, community interest company, that's the model that was brought in a few years ago, specifically for social enterprises. It can be a share company or a guarantee company. It's effectively a midway organisation between a charity and a for-profit company. So it's not a charity. It has to demonstrate community benefit and pass a community benefit test with the CIC regulator, which is effectively part of a company's house. So it's sort of, like I say, halfway house between a charity and a for-profit. It does have limited liability. Industrial and Provident Society, IPS, also known as Community Benefit Society, quite an old-fashioned structure in a way, quite well used in the housing association sector. Some of them are also some of them are charitable, but not registered charities. Again, they're perfectly good in terms of limiting liability. They do provide a full legal protection wrapper around the organisation. And if you're a charity, you may well be set up as a guarantee company owned by guarantee. Again, that gives you the full usual legal protection of being a limited company. And the new one for charities only is the CIO, Charitable Incorporated Organisation. That was set up to meet a concern that charities were having dual regulation. If they wanted limited liability, they had to go into a company structure. Some of them didn't like the dual regulation and company law restraints of being a company as well as a charity. So the CIO is there to address that need, and we're finding that many previously unincorporated charities are now seeking to register to incorporate themselves as CIO to get the benefit of limited liability, and they remain regulated only by the Charity Commission. So that's quite a useful new structure. And as James said, depending on the structure you've already got, you may want to set up a new company to operate the ISPA. And James mentioned a few of the sort of issues to bear in mind if you do that. Okay, so looking at risk in very broad terms. It's one of those areas almost so broad that you can lose yourself in the breadth of risk if you're not careful and never get any concrete proposals coming out the other end. But many of you, I'm sure, already have processes for managing risk, evaluating and managing risk. Lots of people use a matrix which looks at the likelihood of a risk coming up, and the severity of the consequences if it does come up. And that's a very good, simple model. You score both matrices and see where you come out. But also look at the actions you're going to take. What actions are you going to take to deal with what you've identified as the high risks? So it's not a theoretical exercise, it's an exercise to give you concrete proposals as to how you're going to manage those risks. And quite a good way of doing that in the ISPA context is to look at some specific scenarios. So what would happen if your ISPA was terminated after 1 year? Have you thought through all the consequences of that? How would it impact on the premises you use to deliver the services, on your staffing and so on? And these are just sample scenarios. You can make your own scenarios, but I think it's worth doing this as part of your risk evaluation. Say you got to the end of your ISPA and there was no TUPE transfer of staff to another body, so you're left with those employees and left with the redundancy costs arising from their termination of employment. Have you costed all that in? What would it cost? Can you afford it? I'll come on to volumes of service in a moment, but say the volume of services, you've got an expectation of what it might be, but it turns out to be half that when you're halfway through the expected 3-year term. Again, what are you doing about that risk? How flexible are your employment relationships with your staff, for example, to enable you to deal with that? Or, of course, the volume might increase. It might be double, it might be even more than double. Again, test that at the midpoint. How would you respond to that? How quickly could you staff up to deal with that situation? Right, okay. And obviously it's a very holistic process. You should look at all possible risks. And bear in mind, no risk process is perfect. So things are bound to, you might have identified possibly serious risks which don't actually happen. You might have completely missed something that comes out of the blue, not on your initial chart. So you've got to keep this under review. It's an organic developing process. There are some key financial risks. There's no guaranteed volume of work under the ISPA. The services themselves that you'll be delivering will need to be specified in Schedule 4 of the ISPA. But also there could be, depending on how your negotiation goes, there could be scope for the Tier 1 organisation to make dramatic changes at fairly short notice. So that's a very important area of negotiation for you. Whether you can get some degree of guarantee, the ISPA starts from the basis that you can't, and how services might change. And James mentioned, particularly charities, there's a very strong requirement to remain absolutely within your charitable objects. So, do think about building in things about the services can't expand beyond your objects themselves. You don't have to be trying to change your objects midway through a contract like this, obviously. Costs. Again, all the information on cost is blank at the moment, and charges. You will want as much flexibility in there as you can get. If it's a minimum 3-year contract, you're going to want rights to increase your charges for inflation, for changes in the needs of the people you're working with, and legal change that is going to directly impact on your cost of delivering the service. Okay, so again, there's a lot of areas for negotiation there, lots of potential risks, and you can try and manage those through your negotiations and how your ISPA ends up when finally negotiated. NCVR are going to be doing these cost recovery and costing sessions, I believe, so that's going to be a useful thing to go to if you're interested in that. Getting full cost recovery, obviously it sounds like a great thing to get. It shouldn't just be an aspiration. You should really fight very hard to make sure that you are getting proper cost recovery under the contract. Particularly for charities, there's an expectation that charities delivering services that the public sector would otherwise be required to deliver should absolutely get full cost recovery under those contracts. And don't forget, you've got to think about cost recovery in a very broad sense. So all your management costs, all your training, financial evaluation, all the reporting you've got to do under the ISPA, that's all a cost which you should factor in when working out your pricing. Cash flow, very important. You need to look at that in in how you negotiate your costs and when you're going to get paid, how much you're going to get paid. You'll have seen that the ISPA, if you've looked at it, It talks about if there are disputes over invoices, for example, the bit that's in dispute effectively gets parked and you wouldn't get paid that until the dispute had been resolved. So that's an immediate cash flow issue for you. There's some wording in there about they've got to be a genuine dispute, so it can't just be a tactic to try and delay paying you. But those words are quite broad, and you don't want to be in that position. So the more clarity and concrete terms you can get on cash flow, the better. Tax and VAT, I won't really cover that because James has mentioned that a bit. Okay. Prices payable to you, that's going to be in Schedule 5. It's not yet completed, obviously. The services themselves will be specified in Schedule 4, but there's currently very little guidance in the ISPA about how those could be changed. There's a lot of flexibility at the moment on the Tier 1 organisation on possible change of services, which I've talked about already. Similarly, service levels, they could change dramatically, as the ISPA is drafted at the moment. You could have a very dramatic increase or decrease, or indeed fluctuations at various times throughout the ISPA. And you've got to react to all of that and work out, can you manage that risk? Very important concept in the ISPA is the one of service credits. This is if you don't perform the services exactly in accordance with the specified services within your ISPA, and service credits can be imposed on you. They're a direct cut in the charges you will be paid.
Sorry, I should say, just so that we can, because for the recording, we're just going to ask you to, for people on this side, we're a bit further away, we're just going to ask you to kind of speak into the mic, which Luke's got here. Sorry, thank you.
Yeah, sorry. Can primes, does everything have to be put into this at the beginning stage? I mean, can that contract be dynamic, or can it evolve, and can other services then be contracted as a separate contract as you move through the contractual period?
Okay, I think the ISPA is pretty clear that it can only be amended, well, A, with the written agreement of both parties, which is normal, but also B, with the Tier 1 organisation approving, and possibly Ministry of Justice as well, the authority. So don't assume that it's a sort of floating contract that you can request changes as you go and they'll readily get accepted. They may well not. You very much need to pre-specify everything you can.
But if something evolves from the service that you're delivering, you can then establish a separate contract for that piece of work.
Well, you may be able to, yeah. Yeah, you may be able to, yeah. But I think you just need to keep in mind, it's not a standard, just a two-party contract where you can readily negotiate yourself. You've got further people up the tree whose consent may well be required to further changes. Okay, so service credit is very important, and I think I mentioned already, no guarantee of volume under the ISPA. Okay, specific issues, right. So, oops. Okay. Yeah, you're actually required to meet or exceed the service levels. That's what the ISPA says. Clause 4 talks about changes to the service levels and service credits. So those things could be changed quite dramatically. In 6.4, sorry, I should have said there's 3 months. You'll get 3 months' notice if there's going to be a change to service levels and service credits. 6.4, you've got to confirm that you've fully considered and assessed the risks of entering into this ISPA. And subcontracting, you're at Tier 2, you can subcontract down below Tier 2, but as is absolutely standard in all these sort of contracts, if you do that, all the risk will remain with you. And it's not just a question of risk of things being done wrong, it's a question of any subcontracting, even if it goes wonderfully well, involves a degree of management and a management of your subcontractors. So that has its own cost, it's got a time input from you, and you need to factor in all those potential costs.
So, in terms of risk, one of the big risks will be the contract between the Tier 1 and NOMs. Will that be in public view, so you can see how much risk is being passed down the food chain?
think it is going to be in public view, but I'm not totally sure about that.
I think my understanding is that you can ask for it, you can ask to see it, and you should. There may be elements of it which will be deemed to be commercially sensitive. So certainly it should be requested. I'm not sure that it's going to be... I would think it's unlikely that they're going to put the whole of a commercial contract into the public view.
There is certainly reference to your level of contract being in the public domain and subject to confidentiality issues. Okay. Okay, there are a number of other issues which I'm sure you can read in your own time, but there are things like business continuity. You have to have a business continuity plan. You've got to do continuous improvement reporting. There's an annual contract review. So that's just a few examples of the sort of administration that you're undertaking in this ISPA, all of which, as I said, you really need to cost and try and factor into your price. Sorry, just a word on... Yeah, just a word about insurance. Slightly unusually for this sort of contract, there's a degree of flexibility. So you're told you must insure effectively to the level that a prudent business would insure if they were doing the same sort of service. So there's a degree of flexibility there. You might well want to notify your Tier 1 exactly what insurance you've got, so that they can't then, at a later stage, say, well, you didn't do what a prudent business would have done. So you put them on notice of what you've got. You'll also find in the ISPA there are references to maximum financial liability. There are certain things with no maximum, so if one of those is fraud, I'm sure it wouldn't happen, but if there's any fraud in your organisation related to the ISPA, there's no maximum liability on that. But apart from issues like that, a maximum will be stated. It's not currently stated, obviously, because everyone's different, but for negotiation. So there's the greater of a set amount which is to be inserted and the maximum amount paid or payable under your own ISPA. So there will be a maximum liability in there. You need to think about that in terms of managing that cost risk, how much of it is insurable and at what cost. Okay, if there are no more questions, I'll move on to the next section, which is on termination and related issues. Okay, James has mentioned a few of these things, and as you'll be aware, the initial term of the ISPA is 3 years. So there's an expectation you're in this for a minimum of 3 years, and as I mentioned, obviously that has implications for how you price this, what protection you can get in terms of inflation increases in your costs, wage increases, legal change increases, and so on and so forth. Once the 3 years are up, it's possible to either side can terminate voluntarily, so it's not a breach of obligation situation, it's a voluntary termination by giving 6 months' notice. So the 6 months' notice, the earliest it can expire is when the 3 months end. So effectively giving notice
3 years.
2.5 years in. Sorry,
when
what did I
3
say?
years end.
Sorry, yeah, 3 years, sorry. Okay, so notice could be given at the earliest point, 2.5 years in, to take effect 3 years in on the expected end of the initial term. Not sure I got the wording of this completely right, but there's a wording also in the ISPA that for any voluntary termination, you're going to need consent from up the tree as well. So you don't necessarily have a free rein in giving a voluntary termination notice. You may also have to get consent further up.
Is that
Sorry.
change of government?
Can we just give you a mic? So.
Is that unaffected by a change of government? So if there's a change of policy on May 2015, it's still going to be 2018 for the first ISPA contracts?
Yeah, I think as long as these governments...
contracts
Sorry.
come up renewal.
Tier 1
Tier
contracts.
2 contracts presumably won't
Tier-
be signed until the Tier 1 contracts. So they're not going to be
Correct.
signed until April
Yeah.
2015.
Tier 1 contracts are 10 years minimum.
Oh, right.
So whether there'll be provision for the government to get out of those Tier 1 contracts if there's a change in policy, I'm not sure yet. James, is James here? No, he's gone. Do you know if there's a provision for the government to get out to terminate the service agreements of Tier 1?
Oh, yeah.
Yeah.
Lots.
Yes.
It's highly, you know.
So there's there's a real risk.
But as I say, that's why I think, despite the fact that Tories may want to lock the next administration into this, civil servants always give governments very significant freedoms to terminate contracts, and I think that might well happen. I mean, I think that the difficulty is once Ben starts to speculate what might follow, and Labour isn't against provision by voluntary community sector organisations. They just might want more of the core, the Tier 1 elements to be back inside the state bureaucracy, but I think we just speculate.
Yeah, okay, thank you. And obviously, as we've heard earlier, if the services agreement, the head contract terminates, for any reason, your ISPA will be terminated immediately, no notice. There's the usual provision about insolvency, so if either side goes in, sorry, go on. Yeah.
Ian Whitehead from Citizens Trust. Just a quick question on termination. In ISPA it says that service levels can change, 3 months notice. So if they change downwards, are we still locked into this termination? Or we have to be...
You've still only got the same termination rights, which I mentioned a moment ago, which is the 6 months at the earliest, to take effect at the earliest, when the 3 years are up. Okay? So again, that's a risk, as you say. You're mixing service levels which may change dramatically against a very rigid initial term, 3 years, which may have very unfortunate consequences for you as a provider. Again, you may be able to negotiate some of these points.
I hope so.
Yeah, sorry, I was just talking about insolvency. There's a fairly standard, some wording on insolvency. If either side is insolvent, the contract can be terminated. Material breach, this is, again, it's relatively standard stuff in all sorts of commercial contracts. But each one is different, so you need to read these carefully. Material breach, that's not currently defined. And it's not always defined in contracts, but it can be useful to define it for your own contract. It is made clear this could be a single event or it could be a series of events. So it's possible that if you've got something quite badly wrong, that could be treated as a material breach, and the termination provisions could then be implemented against you. Let's say breach. Sorry. Cannot be remedied. So, a very serious breach can't be remedied. You go straight to termination. A time limit would be given. 30 days you would have to remedy a material breach. If you remedied it, it goes away. But if it's a repeated or persistent breach, and that means it's the same or a similar issue coming up within a 90-day period, that also can be treated as a material breach. So as with many contracts, a relatively more trivial issue can become a material breach with serious consequences if you start repeating the same sort of thing. Okay. And obviously, material breaches can lead to termination. Yeah. Okay. Okay. A couple of other things. Force majeure. You'll have heard that terminology, I'm sure. The basic idea is that if something happens that's outside either party's control, that if it stops you performing your contract, you shouldn't be penalised for it. And that principle is here as well. So, for example, recent floods, if that was you and your premises were flooded, you genuinely couldn't work, you'd have to have, you'd be allowed some sort of relief under the contract for force majeure. It links, of course, to things like business continuity planning, where you've got other obligations to have a business continuity plan and so on. And it links to insurance as well, perhaps. If this happens to you, you've got to give notice and take steps to minimise disruption. But while you're unable to provide your service, well, the contractor may get in somebody else to provide your part of the service. You won't get paid, obviously, while you're not providing. So again, think about business continuity insurance. You may be able to cover that risk. And once you've dealt with the issue, you can resume provision of service and getting paid for it. Relief event. This is where the terminology gets a bit strange, slightly unusual. A dependency, so-called, is something that the contractor is obliged to do under the contract, so that they do have some obligations to do things like provide you with information that you need to carry out the contract. You won't be at fault, you won't be treated as being in breach of your obligations if you're in breach only because of this failure by the contractor further up the chain. And there's a degree of discretion as to whether you'll get any compensation for any extra costs you've incurred.
So can I just ask, if a tier 1 provider is in breach or is removed by the MOJ, and as a tier 2 provider you have a contract with that tier 1 and they're removed, is there any protection for the tier 2 that if a new provider comes in they carry on those contracts, or is it just clearly back to termination?
So can I just check, so you're asking, would the contract move from one provider to another if there was a termination?
Yeah, I don't know. I believe not, but...
I don't think so. It does not clear, but it does look as if there would be novation to the replacement provider. If tier 1 gets terminated, you get terminated, even though it's not your fault. But in practice, would whoever was taking over the service want more service? Quite possibly. Would they want to try and drive the price down? Quite possibly.
Okay. Any more questions on that sort of area, force majeure and so on? So just some implications of contract loss. What would happen if you lost the contract? Obviously lots of things might happen. You might have to make yourself redundant. You might have to get out of premises. You might have taken 3-year leases on premises to match your 3-year expected initial term. Suddenly you don't have that contract anymore. What are you going to do with those premises that you need to pay for somehow, or you might have break rights to get out of the lease. Depends how flexible your arrangements are. You almost certainly will have service contracts with other third parties, whether it's cleaners, photocopier rental companies, that are necessary to your work under the ISPA, but they might not be necessary to your other remaining services once you've lost that contract. So again, how easily can you get out of those contracts or minimise the cost of getting out of those contracts? You may have volunteers. They may not give you an actual cost in cash terms, but they're perhaps a source of reputational problems if you treat your volunteers badly. And you may have damages and contract claims against you as well under the ISPA or under other contracts. There are a number of places where the ISPA says that while the tier 1 can take certain actions, these against you in the event you do something wrong, these are not their exclusive remedy. So watch out for those. They're just illustrations of things that the tier 1 could do against you, but they're not the only things that could be done against you. So damages claims may be made against you if it's your fault that the contract ended. Okay, contract changes. There's no limit to the amount of changes that might be made. For example, no limit to the extent to which the volumes of services could be changed, or indeed the type of services, unless you can renegotiate that. There will be a schedule, Schedule 7, dealing with the process for making changes to the ISPA, but that's, like many schedules, currently blank. Similarly, Schedule 6 on charges, lots of detail needs to go into there, as I mentioned earlier. Dispute resolution, briefly, here's a little diagram, flowchart for you. Meant to be a relatively friendly process, so with a possible mediation in there. But ultimately, as with any sort of dispute resolution procedure, you could end up in legal proceedings if all else fails. But you very much should use that process. Certainly the courts these days are very, very hot on parties to contracts and disputes who don't use alternative dispute resolution and mediation as much as they can before resorting to court proceedings. Okay, so any more questions on that section? I'm going to...
Sorry, just very
Certainly.
quick question.
Thank you.
Elaine Tisdall, Surrey Care Trust. You said there are no limit to the amount of service or contract changes. So does that mean that in the first 3 years when you can't withdraw from the contract, there could be an unlimited amount of changes forced from tier 1 to tier 2 or 3? Is that right? Am I understanding that?
At the moment, that's my understanding
Yeah.
in the contract. Whether you negotiate something different, that's what we're encouraging people to do. I think
Yes.
it's fair to
Do
say,
you
isn't it?
put some, in your negotiations, do you want to put some proportionate limit on the amount of changes that could be put through the contract?
I think you do.
You would only say you could only cope with a 20% or 50%
Exactly.
increase in volume or something like that.
Exactly. I think those are the sort of things that will be important to you, whether it's a proportionate increase or decrease in volume, whether it's change in the nature of the service, as we talked about earlier, particularly for charities with very specific objects that it must stay within. Yes, and look very closely at those issues because they're very key issues for many organisations. Yeah.
Thank you.
Okay, I'm going to move on now to Module 8, which is data protection, confidentiality and intellectual property. Okay, data protection, many of you will know a lot of this stuff, I'm sure. The main legislation is Data Protection Act 1998, originally derived from European law. It's information that's capable of identifying living individuals. That's what data is. They're called data subjects. So there's both personal data, which is anything that identifies any person, and sensitive personal data, which is where there are higher levels of consent required to use the data. Things like people's religious beliefs, whether they have been charged with any offence, whether they're members of trade unions. So there are a number of categories called sensitive personal data where you need to take more care over getting consent. You need to be clear who's the data controller and who's the data processor. The ISPA works on the basis that the Tier 1 organisation is the data controller, so they're in charge of deciding what data is kept and what it's used for. And you'll probably just be a data processor, but you may well also be a data controller for other areas outside of the direct ISPA material. It's usually the data controller who has the higher level of responsibility. You may have seen in recent years that the Information Commissioner's Office, the ICO, has had a lot more power to impose penalties against organisations who breach data protection law, and that can now fine people up to £500,000. And there have been many fines. One in particular against a charity for £70,000 for leaving some very sensitive material, paper copies of documents, outside a personal address because they couldn't get the envelope through the letterbox. So very, very significant amounts of money are being fined. Voluntary sector is not exempt from this, so you do need to take data protection quite seriously. Okay, now that's a few general things. Here's some data protection issues under the ISPA. So as I say, the ISPA makes clear that the contractor, that's the Tier 1 organisation, is the data controller and you're the processor. You must only process personal data in accordance with instructions of the contractor, Tier 1, and which is reasonably required to be processed in connection with the service. The word processed, a very vague sort of word. The Information Commissioner's Office basically says that anything you do with data is treated as processing. So if you have any involvement with data, that's processing. And remember that data is not just information held on computers, it can be manual data, hard copy data, if it's kept in a reasonably ordered system, filing system. Yeah.
Thank you. It says there you must not disclose personal data to third parties other than employees or subcontractors. What does that mean in terms of our information sharing agreements that we have with police, probation, prison service, etc.? Because we do disclose personal data, but with the consent of the party involved.
Yeah, and you can do most things with consent. You may need to tweak the wording in your own ISPA to reflect the arrangements you have already. But one point I was coming on to is that you must be, almost the key issue about data protection is you must have very explicit consent to sharing anyone's data with anybody else.
Which we have in place already.
Okay. And as I say, particularly where it's sensitive personal data, including whether someone's been alleged to have committed an offence, it's sensitive personal data, you need a very, very explicit consent to share that information about that person.
Because that kind of comes back to the whole risk management issue.
Oh yeah, totally, yeah. Okay, so you must, it's sometimes called informed consent. The people whose data you're sharing must have a very clear understanding of who you might share it with, and you need to have very good records of that. Again, that's something that the ICO is really hot on and may well check. Good. Okay. Okay, you're meant to keep lots of records, of course, under the ISPA. Overheads, expenditure, performance, payments, a lot of the other things we mentioned, like the business continuity plan and so on, and the annual improvement plan, service improvement plan. In terms of the risk, if you get it wrong, it's your risk if you make mistakes in keeping these records, and both the contractor and the Ministry of Justice can request sight of your records. And it links nicely to the next, sorry, not the next one, but in a couple of slides. Freedom of information. The ISPA makes clear that the public body freedom of information obligations are passed down to you as a contractor. And the time limits are very, very short that you may have to comply with. So the better your records are, the more you're able to comply with them. Okay. How have we got?
Okay. 5 minutes.
5 minutes. Okay. Okay, I'll have to move fairly swiftly to go through these slides. So you have a duty not to disclose confidential information, which is defined in the ISPA, quite a long definition. And you can only use that confidential data, as information as it's described here, for the purposes of providing the services under the ISPA. You can disclose on a need-to-know basis to employees or subcontractors. Okay, freedom of information I mentioned. You yourselves are not directly covered by the Freedom of Information Act if you're not a public body, but the ISPA does pass down these obligations to you to comply with any requests that are made to the public bodies. So you're required to assist in responding to requests, and you must adhere to these tight timelines, 5 working days. So that's pretty short. You will need very good systems to have that ready in time. Again, there's a resource issue there to factor into your costs. Intellectual property. This is relatively standard in the ISPA. So if you've got background intellectual property that you already own, that obviously remains your own. You retain all the rights of it. There's cross-licensing of your rights to them and their rights to you. Probably the most important thing here is that any materials produced in connection with the ISPA, so any useful material that potentially has some intellectual property attaching to it, most likely copyright in materials you produce, that would belong to the MOJ. So effectively the contract is taking that right away from you, which would otherwise be your material.
So, yeah.
Yeah, sure.
On that point, if you're bringing something to the table or that's been already produced and that's something that you're offering, for example, training, how does that then sort of copyright that you have over that training?
Okay, well that would probably be, back on the previous slide, intellectual property that you already own, you've already created this stuff, that's yours, all right? So you'll have copyright in that. You can't register copyright, it's one of the weaknesses of copyright, of course. But
if you could show that,
if you could show, yes, you could show, look, here are materials X, Y and Z, we're making you aware that these are pre-existing, they're not something that we might create during the ISPA. Yes, make them aware. I think it's a good way to do it here. Okay. Here again, the most important thing really is project data. Materials produced in connection with the ISPA. Well, firstly, they belong to the MOJ, not to you, even if you created them. They're licensed back to you for the term of the ISPA, so you're able to use them fully for those purposes. But you can't use them post-ISPA for your other projects. That's a bit of a... That does limit you in certain ways, and that probably would not be negotiable, but you may want to try. Okay.
So we have a question just over there, yeah.
Can I ask you a question about the data? Does that also relate to things like evaluation of outcomes on services delivered and reporting on those and how that's used in public domain?
Sorry, can I just...
You're running a service, you're then evaluating the outcomes of that service for the service users. Does that information or that data then belong to the MOJ and can we as providers use it post-contract?
I think it does, yeah. It's going to depend on the definition of project data.
Can I just make sure that everybody heard that? So it's about if you're creating data, even if it's an evaluation of your services during the contract related to the contract, can you then use that data after the contract ends?
I mean, obviously you'll need to use it for your own financial reporting, for example. That I'm sure nobody will try and stop you doing that because you've got a legal requirement to produce your accounts. But no, if it's project data, inevitably broadly defined in the ISPA, as many of these things are, it fundamentally belongs to the MOJ.
But if it goes into a set of accounts, it's then in the public domain.
It is, yeah, exactly. Yeah. Well, it's probably going to be in a different format, isn't it? So you're complying with the rules on accounting, albeit you may be using some of your project data, I'm sure.
And I think there's a risk to be attached to it. So are they really going to chase you down after the contract's ended over you publishing an evaluation saying what a fantastic job you did?
Yeah,
probably they're not going to sue you for it.
In reality, it's a meaningless limitation, isn't it?
In
reality, it's a meaningless limitation.
Yeah,
the MOJ can't control anything.
It's a protection. It's a protection for them if they want to.
Yeah.
If they want to challenge something.
Yeah. So really, if you're the MOJ, they'll be looking a number of years down the line, potentially, if they have to justify this, and saying, well, look, we want to run these things as efficiently as possible in the future to help the public purse. We don't want to lose useful material that will help us do it again. They don't want you coming up and knocking on their door saying, hang on, that's our stuff. You can't use it, obviously. It may be very, very, very tenuous, I know, yes. But
the ISPA says you can only use it. Sorry, the ISPA says you can only use it within the contract period anyway.
Exactly. So it's licensed back to you for the contract period. It says that. Yeah, I know. Yeah, quite right.
We've been asked quite a lot about intellectual property from other organisations who are worried about losing their their way of doing training in prisons, for example, about that disappearing. And it is worth you going and negotiating that. But the reality is that if somebody wanted to steal one of your staff members and they wanted to run the training in prisons, they could probably do that. It's not easy to trademark training or put that into intellectual property. It is more the training materials which somebody can go and rewrite somewhere. So actually the controls aren't that strong anyway for you. You want to continue to be the service that provides that training the best, really. So it's not likely that if you've got fantastic trainers and are using offenders to deliver the training and you do it in a really good way, that just by taking your training material, somebody's going to be able to replicate that anyway. So it does sound scary, but it's not necessarily as terrifying or as protective as people think.
It's virtually impossible to enforce intellectual property rights on the sort of material you're talking about.
I would say it is very, very difficult. I don't know if James...
Virtually impossible.
Virtually impossible.
Yeah, I mean, any copyright case always looks at, first of all, someone's got to prove they created some material at a point in time. Pardon?
And it is exclusive.
Yeah, it's there. It's got to be original work, for a start, created by that person at a point in time, and then a comparison with the later work. To what extent is there?
Who's going to waste the time and money to prove that?
Yeah. Depends what it is, Depends what value it's got. But anyway, that's the end of that session. So if you've got any further questions, please let me know.